hot. Sometimes we forget time tends to
Yeah,
go away.
yeah. All right, we are on. So, welcome everybody. It's Dan Bouchard with Sara Rodriguez, the attorney at Titan Title, and she is also a fellow uh, GCAAR Forms Committee member, like I am. So, we have a wealth of information between the two of us, and she is more than amply qualified to run the show here. So we're going to proceed with discussing the contract changes for that were issued. I believe it was July 22nd or 24th, 22nd, I think. That GCAR released these changes, and they are in effect right now. So without further delay, Sara Rodriguez.
Thank you, Dan. And as a disclosure, we should both say that the way that it works in the GCARS committee is that there's a bunch of us that, say, hey, we should do this, we should do that. Sometimes we get outvoted. So if you don't like something that you're seeing with these changes, please let us know. We'll take that feedback back to the committee, but don't throw anything at us. Again, so let's go ahead and get started. Let's start with the conversation on if you saw, they did in July, they did a release and it involved updates to 28 forms. Anytime that you see that little red circle, it just means that there were updates on the form, but it's not a new form. We're going to be talking about two brand spanking new forms, updates to 18 forms, and the removal of 8 forms, including what I think is going to be the big one that everybody wants to talk about, which is the removal of Form 900, which is the REA. I think that is going to be the form that everybody's talking about, and that everybody's going to want to have something to say. So I wanted to briefly mention some of the smaller updates and some of the removed forms. So Form 909 and 920, it was just updated so that it can be allowed, the form can be allowed to be used for unimproved property. That's it, not a big deal. Form 1361, Agricultural Reserve Disclosure Notice, the link in paragraph 1 was updated. Form 1352, the Conventional Financing Addendum, some typos were corrected. And then Form 1223, the Rental Property Inspection Report, and Form 1318, Important Information for the Purchase of Real Estate, was updated so with some language to reflect inclusive terminology. So even though these are included in the 28 forms that GCAR is counting, as you can see, it's just a few typographical errors or maybe some updates of links that actually work. There's nothing major to be talked about them. Two forms that were removed were Form 802, the escrow agreement. And the reason they took this form out is because the reality of the situation is if you are going to do an escrow, the title company is going to have their own escrow form. They're not going to allow you to bring one. That's the one they want to use since they're the ones that are holding the money. So GCAR decided just to remove this form so that you don't have to get it signed and then have to explain to your clients why you have to sign the one for the title company. And Form 301, the seller paid broker compensation notice, was also removed. And this was removed because honestly, the form was just created in response to the NAR settlement guidelines regarding agent compensation. And now that we have updated some of the paragraphs, which you will see in some of the forms, that form is no longer needed. So let's dive in. This form is one of the brand spanking new forms, and it's Form 1010, and it's the licensee status and agent relationship disclosure. Maryland and DC law have added additional things in which you have to disclose if you're a realtor. So I feel like this is a great form. I can't tell you how many times I get a phone call where people are like, hey, Sara, I'm working with this buyer and they're like my uncle's cousin. Do I need to disclose it? Well, listen, Here you can see that it is now extremely detailed as to what you have to disclose. Section 1 is a disclosure of the licensee status where you have personal interest. And it says, I am acting as a principal in this transaction. I'm the buyer, tenant, or lessee. I'm the seller, landlord, lessor, or I have an ownership interest in the entity that is the buyer, tenant, lessee, or seller, landlord, lessor. So if you are owning it in an LLC and you have ownership interest, then you can go ahead and disclose it there. You will see section 2 is representative interest. I am acting as an agent representing a member of my immediate family. And I love this because it goes further to define who is considered immediate family as defined by Maryland and DC law. So again, guys, sometimes every state has a different definition. And what we did here is we took Maryland and DC law and we did the biggest one of them all, all of it inclusive so that you could use this form for both of them. Dan, did you have a question on that?
Nope.
Oh, so a member of my immediate family or an entity in which such a family member has an ownership or legal interest, and it tells you who that immediate family is. This one's interesting. An employee of the real estate brokerage with which I am affiliated or an entity in which such an employee has an ownership or legal interest, an employee of a team or group of which I am a member or an entity in which such an employee has an ownership or legal interest, and my employee or an entity in which such an employee has an ownership interest. So I thought that this was really interesting. I love it. In some other states, there's like this one part in the contract that just says, hey, you need to disclose, and it doesn't define it. So I really love the fact that they were very thorough on this form, because that way, if you're doing any properties in DC or Maryland, you can just go ahead and take a look, and this is updated with the new law. So now, Dan, I believe, did you work on the cooperative financing addendum?
I did, and this was in fact my big baby.
I love it. So I knew it, and I'm going to let you talk about it, but I just want to say something real quick. So a new form, a form 1353, a cooperative financing addendum, so well needed. You guys worked so hard. And then the cooperative seller disclosure resale addendum was updated. That's why you see that little font in order to be able to work well with this one. So Dan, what do you want to tell us a little bit about this form?
So in the past, what we had was a situation where co-ops didn't have a financing addendum that was specifically geared for the co-ops. And so what everybody was doing was using the conventional financing addendum and simply applying it to the cooperative financing. Well, the, for a lot of different reasons, that really wasn't quite appropriate because the terminology for cooperative financing is different than it is for conventional financing and FHA and VA as well, and as well as USDA. So what we did is we took the template of the conventional financing, rearranged some of the terms so that it would be more appropriate for the use of within co-ops, and that's where we came up with this form. And we had lots of participation from lots of different cooperative settlement attorneys. Not all settlement attorneys will do co-ops. And sometimes there are specific settlement companies that have to focus on those. And so we had specialists from that business that kind of drove that bus for us. And so we went back and forth with a lot of different changes and a lot of revisions. And it ended up, we tried to mirror the conventional financing contingency in as much as we could so that we kept the formatting and the structure as much as we could and simply tweaked it so that it would apply to co-ops. That's basically the theme of what we did. I'll let Sarah go ahead and dive into the specific details of what it covers.
Well, I really love the fact not a lot of people do co-ops, as you said. In fact, at Titan Title, We know how to do co-ops, but we also know that it's more expensive for people to do co-ops with us than it is with some of those title companies that are geared towards it. So we refer it out. And the reason being because co-op is different. You're buying shares. As Dan said, the financing is very different. And when people were using conventional financing, but then the type of financing that they're getting is different, if there was a rejection, they were exposing their clients to losing their earnest money deposit. If you take a look at this cooperative financing addendum, what I like is that not only does it explain, first of all, it's in a template and a format that does mirror your other financing agreements, but it also kind of walks through a little bit of the differences when it comes to a co-op, which is one of the updates again that they did in this next form, which was Form 924, which you see to the right, where they call it a cooperative maintenance fee instead of just a fee, because it is a different type of fee. And for lenders and everything else, they kind of have a, those nuances absolutely make a difference. Now, again, if you take a look at it, it is very similar other than the terminology to for what a financing contingency is. And other than the terminology. So that was Dan's baby. Yep, Dan. Anything else
Yep.
that you wanna
So, Sarah, does this financing addendum cover the underlying mortgage?
does yes.
No, it doesn't.
It doesn't?
No, no, we're not talking about the underlying mortgage here in this situation. This is only for
Shares.
the purchase, right, the
Yeah.
shares.
Oh,
So
you
it's
mean the one for the whole building? Yeah, I'm so sorry.
correct. Yeah, the underlying mortgage. Yeah, in co-op world, you've got an underlying mortgage that the association finances its activities with,
Yes, yes,
and
yes,
that's
yes.
called the underlying mortgage, and that's what Sarah was just talking about. What we're talking about with this co-op financing addendum is just the repurchase from the seller themselves. So that's the resale of the seller's interest in that
In the
cooperative.
co-op. Sorry, I thought you were talking about the seller's loan,
Yeah, yeah,
not the
but
co-op.
underlying, yeah, the key word there being underlying means the association's funding source.
Yeah, so again, one of the biggest reasons where a co-op is different is because in a co-op, you're buying shares that align to the square footage or the unit that you're buying. So that's why everything is a little bit different. That's why the terms have to be a little bit different. If you see right there on paragraph 1, specified financing, it talks about first loan security agreements, because that's what they're called. Because again, you're not purchasing per se the real estate, it's more about the shares in that unit. So awesome. Okay. Now, this one was my baby. So if you hate it, you can feel free to say something to me. There was a lot of back and forth with this one. And in this type, has one of the biggest updates. And what they wanted to do is the board for GCAAR told us that they wanted to create one inspection contingency notice and or addendum. So if you work with GCAAR and you work with MAR, you notice that in MAR, it's just the one form that they use for inspection. It's the one form that they use in order to get things released. And in this particular case, GCAAR wanted to do less is more, less forms are going to be better. So what we were tasked with was creating a notice and or addendum that could be used to release these contingencies. So the first thing that you're going to notice in what I've highlighted is that it says this notice pertains to the following inspections. And then you're going to select all applicable contingencies or use a separate notice for each contingency. So it does give you the opportunity to either release a few at a time Or if, for example, you have a home inspection that has 5 days, but then your radon or well inspection has 21 days, it allows you to use this form to release the home inspection and then not release the other inspections. So that's the first thing that you have to note, is that this one, you can use it to release multiple at a time or one at a time. And you have to select the ones that you want that this is going to be applicable to. So you're going to see on the form that it has option 1 and option 2. And what I did is I screenshotted it so that you guys could see it. It says, select either option 1 or option 2 below as allowed by the inspection contingency. Now, why did we put that? Because depending on what you negotiated, you might negotiate that, you are not going to, you only have right to void on a home inspection. You don't have right to negotiate. So then you're only going to have option 1. You're not going to have option 2. So here we're saying, hey, select either option 1 or option 2 below as allowed by your inspection contingency, because this is not creating additional rights. This is just a form for you to use with whatever you negotiate on that first contingency. Now it does say once notice is delivered with 1 or 2 selected, the other option shall no longer be available. This is not new. This is the same thing that we did in every other removal of contingency. Another thing that we did here is that we were talking and we said, okay, we know that when we're writing our contracts and our contingencies, we always had negotiate first and right to void second, because we want people to negotiate and get to an agreement first and then to void if no longer. But the fact of the matter is that if you void, then you don't need to go through all these other pages of the contract. So we moved right to void first, and then option 2, you're going to see, is the right to negotiate. So that was a big move. And then what we did is we moved all of the addendums that talked about contingencies to mirror right to void first and right to negotiate second. So if you look at your right to void, the only signatures that are needed are the buyer's signatures. So that's why it's in a little box. And it says, buyer declares this contract void and all parties shall immediately execute a release agreement. This notice may only be used if permitted by the inspection contingency and parties have agreed to the right to void. Again, you have to have the right on your contingency. This does not create an additional right for you. So if I did a home inspection with no right to void, then I can't just create one because I'm using this form. This notice is not available for the termite inspection contingency or wood destroying contingency. And it says if right to void is permitted under radon inspection contingency, this notice must be accompanied by a radon testing report, which confirms the presence of radon that equals or exceeds the action levels established by the EPA. So again, what we try to do is we try to consolidate all of these inspections on how to void. Well, for the wood destroying insects, you don't have the right to void, so this one, is not available for it. For radon, it says that if you are going to void, you have to give the radon inspection report. So that's why we included that language in there. Now, most of the time, what we're going to be talking about is this part right here. Yes,
Hey,
Dan.
Sarah, before we move on to that, so one of the scenarios that we often see in a right to void only situation is the buyer will come in and select a not right to void option, but then they will also attempt to try to negotiate later as well. And we run into that over and over and over again. Probably that's a big discussion that is more so geared towards agent education, and the agent is not using the situation very well informed in a very well informed manner. But can you talk about whether or not that gives us that truly does give us a right to negotiate, and what we can and can't do with respect to a subsequent attempt to negotiate when they're only exercising the right to void?
So I love that question, and I'm gonna play a little bit of devil's advocate with that. So this is what, you know, this is what happens. If you have the right to void only, you have the right to void only. And it says that with the right to void, if you look at any of the inspection contingencies, it says, this right will terminate at deadline unless by deadline buyer delivers to seller notice declaring this contract void. So what happens is, Dan, to your point, and I think that started years ago when we had these bank-owned properties, where the bank-owned property says, hey, you can do an inspection, but you void only, we're not going to negotiate with you. And then people started voiding. And the bank said, well, wait a minute, why are you voiding? Like, what's going on? Or it's something really simple, really, it would be $100 or $500 to fix it. And the people didn't want to do it. And the bank said, well, why didn't you tell me? So where it gets tricky, so it doesn't preclude, there's nothing illegal if I have a right to void only for me to call the other agent and say, hey, I know we have the right to void. The water heater came back where it's on its last leg. And my buyers are buying a new house, or, something's wrong with the roof. And if your sellers would be willing to pay for it, my buyers wouldn't void and they would stay with the contract. Okay, there's nothing illegal with that. Now, the problem is, how do you protect yourself and paper trail it correctly? Because, if the other party says, well, let me talk to my seller, and your timeline passes, then just because you are negotiating, the negotiating paragraph doesn't immediately go, and then you have, 3 days to do this and do that. No, no, no. You have a right to void unless you create an addendum stating that you now have different terms to the contract. And I think that's where I see a lot of agents get burned, is because, they believe because they're in negotiations that now all of a sudden the right to negotiate paragraph comes along and they have 3 days and they allow the timing to pass. So you have to be very careful, because now you have to amend the contract to state that you are going to have a right to negotiate. And how is that right to negotiate going to happen? So does that clarify, Dan?
Yeah, it does. What about a scenario where, and I've seen this many times, where you have agents that write in the notice, this contract is void as of whatever the deadline is, unless unless seller agrees to negotiate terms, um, yada yada yada, and you see some kind of language to that effect. So that, and then
Doesn't
if
count
the
as a
part,
notice to void.
so what's that?
Does not count as a notice to void.
Correct.
Yeah, exactly. So we see that a lot, and so I just wanted to clarify that's where you were kind of headed with that.
Yeah, I mean, I agree with Eric. You have to, it's really simple. It's like, right to void, this right will terminate at deadline unless by deadline buyer delivers to seller notice declaring this contract void. And if it's a right to negotiate, then you have to see, and I think what they're trying to do is, in the right to negotiate, there's some language, right? So the right to negotiate, and we're going to see it later here, because what we did is we took all of these things and we put it into one form. You have, three things and 3 pages, and we tried to put the information that you needed right there, so that you didn't have to go back and say, okay, well, I have a home inspection contingency or a septic system contingency. Let me go back to the contract, or let me go back to the clauses and take a look at it. But a right to void is a right to void. This right here is your right to void. Buyer declares this contract void, and all parties shall immediately execute a release agreement and a signature. Now, does this mean that someone else can't just take a right to void and void? No, they can absolutely do that and we're fine, but we're trying to give you the form to do it.
Perfect.
So,
To Dan's point, I think it was interesting. I've been in the game a good bit, but it happened to me, and it was a bone of contention, and it happened with another agent who happens to be a manager of a Long and Foster office over in your neck of the woods. And she put in, this contract is void unless seller agrees to credit. It happened to be $21,000 at the time. And they snuck it in like 15 minutes before the contingency expired, which was an interesting play. And her attorney, who happened to be at RGS, or Universal, I mean, um, was in agreement with her. And her initial attorney, Rothstein, was not at all. And it was a good play if you're trying to be sneaky, I think. But
So
definitely,
Eric, let me ask you again. So, and I apologize because I'm more visual than
uh-huh,
auditive. Especially because English is my second language. So sometimes, by the time that I hear something, so I like to look at things. But you're saying she sent a notice that says this contract is void unless blah, 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 right?
right. Mhm.
And it's a notice.
Yep.
She's trying to make an agreement in a notice. Can a
Yeah.
party have a unilateral right to force another person to do something?
Nope.
No. So listen, I've been an attorney. I'm not going to age myself. Okay. I've been an attorney for a really long time. I can tell you that even in the forms committee, Dan knows this, there were some times where the attorneys in the group, we'd get very heated because they were like, well, this is how it is. And I'm like, but that's not what you're saying. That's not what
Never.
you're saying.
That never happens.
And what the law says is what's in writing. A notice is a notice and is not an addendum. You can't, force the other party to do X, Y, or Z if they don't, with that notice. So
So
that's why
if we would have initialed yes to the credit.
if you would have agreed to the credit, then it becomes an addendum and then it becomes enforceable.
Yeah.
So it was very is a, it was a so her client was a lawyer, and I thought it was mm, I think maybe she underestimated some of the other parties to the contract, but the I think if someone uneducated was presented this, I think they would probably bite. And
Oh,
it was
trust me, Eric, there's sometimes when I look at things, people send me things, and I'm like, I can see why you're trying to do this, but you worded it weirdly, but still this is what's going on. So what I always say is let's strip it to the basics. Let's strip it to the basics. What does the contract say? What does the contract say? What does the wording say? What's the legal concept of a notice versus an addendum? What are the legal differences? And then you take it from there. But to your point, I mean, there's a lot of the time where people are trying to do what's called unauthorized practice of the law and and you have to protect your client the best as possible. But I mean, here now we did make a change on the contingencies where the contingencies now say if buyer fails to obtain inspection reports, fails to deliver inspection reports to seller as applicable, or fails to deliver this form or notice to void prior to deadline, this contingency will expire and this notice shall remain in full force and effect, blah, 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 blah. So we are trying to make sure that we're kind of like, hey, these are the provided forms, this is the provided instruction so that people don't get super creative. And always feel free to give me a call or email me. I did put in the chat both my cell phone number as well as my email address, so that I'm happy to take a look at any of the information that is sent and give you my 2 cents on it.
great.
Okay, so then you have option 2 of the inspection contingency notice and or addendum. And this is the one where I feel most people are going to live in. So for inspection 2, which is the right to negotiate, you have the A, which is corrective actions and or credits. And you will see that we have 1 and 2, which is the corrective actions, credits. And then B is going to be the right to void based on this right to negotiate. So the first option to void is the one on the contract where it says right to void. Hey, I'm not even going to negotiate. I just want to walk out. As you all know, on these inspection contingencies, you still further have a right to void once you start negotiating if you don't, come to an agreement. So on option 2, you have the right to negotiate. It says, in the event this notice becomes an addendum. See, this is where we clarified. The first one is a notice. Let me go back to it. That's why only the buyers have to sign. I'm giving you a notice. The contract says I only have to notify you of me walking out. Only the buyers have to sign. This now creates an addendum. So in the event this notice becomes an addendum, the provisions of this addendum shall supersede any provisions to the contrary in the contract. It says, again, this is not new. We're just reminding you what the inspections say. The inspection contingency provides that failure of either party to respond within 3 days after delivery of notice will result in acceptance by both parties of the terms of the most recent notice. What I think in your particular case, Eric, from what Dan is saying, is that they try to do a variation of this, of saying, if you don't respond, then you've agreed to X, Y, or Z. So I think that's probably what they were trying to do and why it got a little bit kind of like, gray. The difference is that in your inspection contingency, when you have your right to negotiate, you're already setting those terms to the contract. Whether if you're bringing something out of the blue, contractually, you don't have the right to the contract. So again, this is nothing new. It says option B below may only be exercised by the recipient of the most recent notice under option A. Again, that is the option to void under the right to negotiate. And it does say that option B may not be exercised by the seller as first response to buyer. That is nothing new. That is part of your inspection contingencies. So again, the right to negotiate says that the buyer is going to give the inspection addendum to a copy of the report from the inspection together with this form asking for something. And what this part says is the seller can't say, I void the contract. No, you got to play. Say no, counter, but you got to play. And then after we play the first time, then the parties have the option to void. Right to negotiate A says buyer hereby provides a copy of inspection report. You're going to see that I'm highlighting this because before it wasn't detailed that you had to have a home inspection report with a notice to void. So now we're making sure that everybody understands that they have to have this home inspection report for everything. And it says, the buyer hereby provides a copy of the inspection report and agrees to remove the inspection contingency, provided that seller performs the following repairs, replacements, remediation, corrective actions, and/or provides a credit. And the first thing that we want to talk about is corrective action. And it talks about, note, some contingencies or laws require remediation or other corrective action to be done by contractors or firms with specific licenses and/or certifications per the applicable contingency. This is really, really, really crucial because one of the things that we had to do in order to make it from 5 different forms to one form is that we couldn't put like mold remediation has to be a mold expert. Radon remediation has to be like a specific type of party. So what we had to do, because we couldn't list each of them, is say, hey, you guys, go back to your contingency. And if your contingency says that a remediation has to be done by a specific contractor, then it has to be done by a specific contractor. And it doesn't matter here, a licensed contractor and receipts, if it's completed, you're still in default. So that's something that I want, especially if you're a listing agent, for you guys to be very, very well aware of it, because a lot of the times I think this is where we're going to have a little bit of the issues. And then, it does remind everybody that corrective actions must be completed and receipts must be provided to buyer no later than 5 days prior to settlement, unless otherwise agreed. So again, none of this is new. It is all a reformatting of what the sellers and the buyers have already agreed to in the contingencies. Any
So,
questions? Yep.
Sarah, one of the things that comes up is the receipt has been delivered, but it says, let's say it was an HVAC issue. HVAC contractor service or serviced, HVAC system, whatever. So something very vague. It doesn't really address exactly what the issue was. Does that constitute a valid receipt? Whereas the discrepancy in the report was in the home inspection report said that the condenser was failing. And whereas the contractors put a receipt, service the HVAC unit. Let's just use that as an example.
I would say that that doesn't constitute a receipt because if the receipt, but this is the problem that I have, and this is another class for another day on home inspections.
Yeah.
I know you guys are not home inspectors. Trust me. I'm not a home inspector. In fact, half the time I don't even know what things are in my house, okay? But you have to really look at what you're asking. What I notice whenever there's issues is that we have a lot of realtors that copy and paste what the home inspector said and they put it in their addendum, right? In this addendum. And it's not what the people want. It's, for example,
Apples and oranges.
exactly. For example, sometimes they'll be like repair or, or replace, blah, blah, blah. Well, obviously the seller's going to go with the cheapest thing and they're going to repair it. And then your buyer in their mind wants it replaced. For example, I can't tell you how many times I have an issue with windows. There's a little seal in a window that if it breaks, there's condensation in the windows. And a lot of home inspectors will put repair or replace the little thing, whatever, in the windows, right? And some people will be like, okay, we're going to repair it. They put a little new seal, but the glass is still fogged up because it was already broken. And they're like, well, you literally told me to repair the little thing. I repaired the little thing. I've done what I needed to do. And then the buyer's upset because they wanted a brand new window that wasn't condensed. You have to ask, what is it that you want? Repair, replace, or let's talk about HVACs. Another thing that I
Be specific.
absolutely hate. Do what?
Be specific.
Be specific.
Yeah.
You know
Don't
what's
go and
really
be like,
specific, Sarah, is money. Money is the most specific thing you can do. Then there's no argument about what the repair is, how it was to be done, or anything else. You give it credit and you move along.
I agree with you, Eric, but I also have noticed that with a couple of agents, they'll tell me, hey, I don't want to put money because I don't know how much it's going to cost to do X, Y, or Z, right? Or my clients don't want to have to deal with that. They want it done. So I understand. But what I'm saying is, for example, I'll see a home inspection addendum and it'll say, which now it's not a home inspection, it's an inspection contingency notice and or addendum. And it'll say something to the effect of, um, seller to have HVAC looked at. And then the seller will have an HVAC person come and they'll be like, yep, you need to do X, Y, or Z. And then the buyer's like, well, you need to do it. And I'm like, no, I don't. You said have it looked at. We had it looked at. You didn't ask us to fix anything that they came up with. You didn't ask us to do anything. This is what you're saying. So you have to be very specific. Now, do I agree with you on money, Eric? Yes, except, and we're going to talk about that right now. But for now, everybody understands you have your one inspection contingency notice and or addendum. We start with notice to void only if the first notice to void, which we saw, is only if you have that right to void in your inspection contingency and you're using it without negotiating, just notice to void. If you're starting to negotiate, you have corrective action credit, you have the first page corrective action, and then you have your credit. Let's talk about credit. So in the credit, in purple, the first one, it says, It is buyer's responsibility to confirm with lender that the entire amount of all credits provided from seller to buyer may be utilized. If lender prohibits buyer from accepting any portion of any credit, then said credit shall be reduced to the amount allowed. In the past month, I have had 26 contracts, 26 in 30 days. 26 contracts where they have gotten into a fight because they got a credit for home inspection issues. These were roof or big issues. They already had negotiated seller contribution and the lender said no. And then the buyers at the table were like, well, we're not closing because this is to do a new roof or do a new deck or do a, X, Y, or Z. And you promised me the credit and now the lender's not allowing me to do the credit. And then you know what the worst thing is, Eric? Who do they look at? They look at their realtor. They look at their realtor like the realtor didn't know to tell them. So this is my only thing that I will advise you. If you are going to ask for a credit, number one, make sure the lender is okay. Number two, make sure that that the lender is proactive weeks before closing to make sure that the buyer is going to be able to utilize the full credit. And number three, that the buyer understands that that credit is a credit against their closing costs. It's not money at the table for them to pay the contractor, which has also happened to me, where people are like, yeah, we got a credit, for the roof. And I'm like, oh, no, it was a credit towards your closing costs. I have no money for you. And they were like, well, I didn't know that I have no money to pay for the roof. So those three things are the only things that I would, ask you to take into consideration if you are asking for a credit in lieu of the seller fixing something. Any comments to that, Eric?
Well, I mean, I've not run into that because typically we'll do a principal curtailment or we'll have the money paid directly to the contractor. So it hasn't really been an issue.
Yeah, just again, it depends on the lender. And that's why I want to very specifically notate where in the contract it says it is buyer's responsibility to confirm with lender that the entire amount of all credits provided from seller to buyer may be utilized. I can tell you, depending on the loan, a lot of lenders won't allow you to pay the contractor. A lot of lenders won't allow you to do a principal curtailment. So just, be aware and make sure that you're being proactive with your lender about that. Now, again, because on certain inspections, right, like radon being the biggest one, it is a health risk. We did add in bold here, buyer is solely responsible for any corrective action and or remediation and assumes any associated risk caused by such. It does say, but further, buyer does hereby release, indemnify, hold harmless, and forever discharge seller and broker, as well as any agent, subagent, or employee of broker from any and all claims, liabilities, or causes of action in case the buyer decided not to take the radon remediation money and do radon remediation and they pocket it. Then we added the credits requested herein, if any, shall be in addition to any other amounts the sellers have agreed to pay under other provisions of this contract. And because this is an addendum, not a notice, you will see that it has seller and buyer signature lines in here. And then finally, if you are tracking, again, what in any inspection, you have a right to void, a right to negotiate, and then that right to negotiate says, hey, within 3 days after delivery of notice from one party, the other party may deliver notice from, accepting the terms, or deliver notice continuing negotiations, or deliver notice that this contract will become void at 6 p.m. on the third day following delivery, unless the recipient delivers to the other party notice of acceptance of the last delivered offer prior to that date and time. So this is within your right to negotiate. You have those three options. This is the third option. And we're giving you here notice given by which party, and it has for signatures there. But again, very important, this is not something that you can use as a first response if you're doing a notice to right to negotiate. This is within your, once you're negotiating. Is that understood by everybody? Yes, no?
Yes.
Okay. So,
Kathy's been awfully quiet here. Kathy
Yep,
Sullivan.
I'm just absorbing it all. It's all working for me. Thank you.
yeah, so I like I said, this is as Dan's baby was the cooperative financing one, this was my baby. Some people were insulted in that committee, others were not. It was definitely something to go. Hopefully you guys like it. I do feel like it makes everything so much simpler, everything in one
Yeah.
form.
Yeah.
Okay, moving on. So based on that, now we have a inspection contingency notice and or addendum. So then what we did is we removed a bunch of forms because you don't need a form for lead-based paint. You don't need one for the wood destroying insects. You don't need one for radon. You don't need one for private water, and you don't need one for septic. You don't need a notice and or addendum to negotiate these because you can use this one form to negotiate it. And then we also updated to contingency paragraphs in forms, of course, your addendum of clauses A. We, change paragraphs 2, 3, and 4 to align with this document. 1339 addendum of classes B, the private water supply, the well and the septic ones. What we did is now we defined what you need to do in order to remove this contingency. You need to give us a copy of your inspection report. You need to deliver this inspection contingency notice in or addendum or the notice to void prior to the deadline. So as you can see from the 28 forms, now we're starting to whittle down where it doesn't seem as big, because a lot of these removed forms just had to do with you don't need one because it's all in one form. Okay, now let's talk about the big kahuna. As you all know, we had the REA regulations, this form that had all of these disclosures that you had to add to the Montgomery County jurisdiction. You had a jurisdictional disclosure and then you had the REA. So what we did is we went in and we took all of the disclosures in REA and we put it into the jurisdictional disclosure and addendum for Montgomery County. And so that you only had the one form. Now you will see that they are two forms that you're going to have to use if you have a MAR contract in Montgomery County. If you're using a MAR contract in Montgomery County, you're going to use this jurisdictional disclosure and addendum. And then we're going to go to the next form that talks about Montgomery County jurisdictional addendum to the MAR contract. But this jurisdictional disclosure and addendum for Montgomery County is required for all listings and for GCAAR or MAR contracts. This is required. There's no REA. Now this one is required. Before you had two, we merged it into one. It's the same things. There's nothing new. It's just it's formed into one. So what we did is we wanted to make sure that we were aligned in some of the other forms that you guys have at GCAAR, which is seller disclosures, the first part, and then you have on the second part is the addendum, right? And you sign to that. And that one is going to be on page. So this part 1 and part 2, it goes with all these things. And this is a seller disclosure, which is that the seller has to fill this out with their listing. You're going to see if you take a look at it, that it has, there's nothing new. It has the disclosures disclaimer statement. Is the seller exempt from the requirement of the act? Yes, then it tells you why. It asks you to go ahead and put that. If no, then you have to have the Maryland residential property disclosure or disclaimer statement. And then what we also did is we were able to just take all the links were obsolete, and now all the links actually work. But there wasn't anything that that was anything super crazy about it. Now, again, if you're taking a look at it, it is 11 pages. I didn't put the full thing in here because, to be honest, again, it's all the first few pages all talk about the same. Oh, what did I do? Sorry, guys. The whole having to maneuver the PowerPoint and this, it does create a little bit of a situation for me. But if you look at the form, and you should be able to look at it within your stuff, or you can always just call me and I can email it to you, or the way it is in the forms, you are going to see that a lot of the things are the disclosures. What we did is we bunched them all together, and those things that had buyer signature had have the buyer's initials on there, and we were able to bunch it together. And then what did we do for the signature part? For the signature part, we said, hey, by signing below, the seller acknowledges that they've carefully examined this form and that the information is complete, accurate, and current to the best of their knowledge. So again, because this is something that is a disclosure, the sellers have to sign it with their listing agreement. They sign there, you upload it, and then the buyer will go ahead and sign acknowledging that the seller has disclosed to the buyer the information contained in part 1, seller disclosure, before buyer executed a contract for the above referenced property. So we try to make it very like, hey, this is what the seller has given me. Buyer, as the buyer, I'm signing, acknowledging that you've provided me all of these disclosures. And then the other thing is, again, not all the disclosures are the same ones. The same ones. There's no new ones. What they did do is rearrange them in order so that it flowed a little bit better for the clients. Now, I know we have a lot to go through, so I didn't put in my screenshot the whole jurisdictional disclosure and our addendum, especially because there's nothing new. But if you want me to send it to you, or you want me to show it, I'm happy to show you the whole addendum. Are you guys good with this, or do you want me to bring up the whole addendum?
Carry on.
Carry it on?
I'm good with this.
Yep.
Okay,
Yep.
perfect. Yeah, what I wanted to do again, I don't know about you guys, but sometimes when it's too overwhelming, I don't remember anything. So what I wanted to do was give you the highlights and kind of give you what you need to pay attention to. So again, we talked about this form having part 1 and having part 2. And the part 2 is the part that has what the buyers now have to agree to. It's the resale addendum. It's what we are going to negotiate. And that starts in page 10. Okay. So up until page 9, it's all seller disclosures. At page 10, we have part 2, which is the resale addendum. And this is where we're going to negotiate. The first part is just seller disclosures. The second part is the addendum. So again, nothing new. You've always been to negotiate. You've had to say whether the buyer is a first-time home buyer or not, and who's going to pay what, and what the percentage is going to be. The tax benefit programs, the deposit, whether it's in a non-interest-bearing account or an interest-bearing account. It talks about the homestead property, tax credit notice to buyer, homeowners, property tax credit notice to buyer, and then all the notices to buyer that we usually have. And at the end of that, so you see, there's nothing new. It's just that we bunched it all together. So part 1, which is pages 1 through 9, is the disclosure. And part 2, which is pages 10 and 11, is the addendum. And at the very bottom, we again say, hey, all of the contracts in Montgomery County must have this form, all of them. But if you're using a MAR contract, complete part 1 and part 2 above, but you're also going to have the Montgomery County jurisdictional addendum to MAR. So it's telling you right there, hey, if you're using a GCAAR contract, you only have to do the jurisdictional disclosure and addendum for Montgomery County. But if you're using a MARC contract, you have to do this jurisdictional addendum plus a Montgomery jurisdictional addendum to MAR. Does that make sense to everybody?
Sarah, do you recommend one over the other? If you're representing a seller or representing a purchaser?
It's a great question, Eric. I do. I actually do. Dan, go ahead. What are your
I'm
thoughts?
curious to hear what you're going to say. No, go ahead, Sarah.
So I'll tell you, the MAR contract, one of the biggest differences that it has to GCAAR is on fees. In the MAR contract, it says that the buyers are going to pay all of the settlement costs and that the seller is only going to pay the encumbrance fee if there's encumbrances. So the fees are typically very different if you have a MAR contract versus a GCAAR contract. If I am doing business in Montgomery County and I'm representing the buyer, I'm always going to want to use the GCAAR contract because the GCAAR contract is a little bit more buyer friendly in my opinion. Plus it states that everybody's going to pay their own closing cost. The MAR contract states that the seller is not, the buyer's going to pay doc prep fees. The buyer's going to pay all of the settlement costs, that the seller only has to pay encumbrances fees if they have any encumbrances. So it makes it a little bit more on the burden on the buyer. Now, again, some of the timelines are very different for MAR than they are on GCAAR. On GCAAR, your timelines are 6 p.m. But I say this with a big but, because the next addendum that we're going to see is you are going to see how they are going to change in this addendum most of the things that are different from MAR to GCAAR, they're changing it to GCAAR. So that being said, let's look at the Montgomery County jurisdictional addendum. So again, if you're using a GCAAR contract in Montgomery County, you're going to have to use the jurisdictional disclosure and addendum for Montgomery County. Point blank. If you're using a MAR contract in Montgomery County, you're going to use the jurisdictional disclosure plus the Montgomery County jurisdictional addendum. Here, you're going to see that it redefines some of the terms in the MAR contract. It changes them. For example, property maintenance and condition. It is telling you here how it wants you to deliver the property. It talks about who the settlement agent is, and it talks about the performance and that the seller agrees to pay a reasonable closing fee for services rendered to sellers. It became an issue in Montgomery County with the MAR contract because the buyers were like, hey, I don't want you charging my buyer more because it's a MAR contract versus a GCAAR contract. So people started getting a little bit wise to it. And as you can see here, it's starting to change those terms. So I do like GCAAR better. I think it's, more succinct and it's a little bit easier for clients to understand. I think it's a little bit more kind of like, hey, both of you guys, parties have these responsibilities. MAR is a little bit more like the wild west sometimes in some of these contingencies. And, but it just depends again where your play is. Just note that with this new Montgomery County jurisdictional addendum, they changed some of those terms in the MAR contract, and this is what's going to prevail. So even if the MAR contract says A, this says B, B is what's going to prevail because of contract law. Okay, so continuing on this one, it's not new, but I want to bring it up. Again, I'm so sorry, I suck at PDF. So you can see that I left the little things, I don't even know how to take them off. This is the best I could do. But this is not new, but I can't tell you how many calls I get about this on a daily level. So this is talking about notices and delivery. And when the part that I highlighted is talking about the resale package. Delivery of resale package must, not shall, not may, must be made directly to buyer. Delivery to buyer's agent does not constitute delivery from seller to buyer. This is really important. I can't tell you how many times in these games that we play, I see that the listing agent sent it to the seller's agent, and then the seller's agent, it's not considered delivery. It's not delivered. You have not started the timeline. You have not done anything. You have not delivered it. Now it does go on to say, and that's a law thing. The law states that it has to be done directly to buyer. So again, be very careful if you're on the listing side. If I was a listing agent and I had to deliver HOA or condo docs, I would CC the buyer's agent, but I would ensure that it gets delivered to the buyer so that I don't give these buyers any little way of getting out of the contract, because I didn't deliver it to the right people. So, again, please be very careful with this. I can't tell you how many times, even agents that have been doing it for a really long time, this was the change in the law. So you have to abide by the changes in the law. Okay? Okay. See, I am so long-winded. I'm sorry. It's already an hour in and we still have a bunch of forms to go. So I will try to, any questions so far?
Can I
Yes,
ask you
ma'am.
one question about that?
Absolutely.
So it's provided that the buyer, the buyer's email address is provided by their agent, and you send the documents, PDF, whatever format it's in, electronically to the buyer, and the agent says, okay, received. The buyer doesn't say that, which I understand. Now I don't have proof of delivery in the vein of seller, or the buyer hasn't responded. And that's, I guess, my basis of the question. If I've got it, that I've sent it to the right email address, I have it, it's time, date stamped, I sent this email, and it's confirmed that I sent it to the correct buyer email address. If they don't say, hey, I've got it, or notify me in any way, shape, or form, do I still have delivery?
Yes. So let's go up on the part where it says delivery. And you know what? I can teach a great class on delivery. What does it constitute delivery and all these things? If you look up a little bit higher, delivery means sent by wired or electronic medium, which produces a tangible record of the transmission, such as fax or email, which includes an attachment with an actual copy of the executed instruments being transmitted. So delivery will be deemed to have been made, if you send it somewhere else. So it's delivered as soon as you send it, or if it's in an
And
email.
I like to categorize. I like to further define it by distinguishing between the two words delivery and receipt. So receipt would be what you're talking about, Kathy.
Yes.
You're talking about receipt. The contract here and the addendum doesn't require that a receipt be certified. All it requires is that the delivery be made. And so that's the distinction between the two.
Absolutely. I love that, Dan.
Kathy,
Yeah.
when you send that out, you should just say acknowledge receipt as well. And sometimes
Yeah.
they'll do
And
that.
I do. I always say on my emails,
No, you
please.
don't. No, you don't, Kathy.
I do. And that being said, sometimes they still ignore it. And then I'm chasing them to get them to finally say, oh, yeah, I did get that 2 days ago.
But it's
But
not
I'll keep chasing them. Yeah.
it's not required by the addendum.
It's
And
not required by the addendum or the law. It just says it
yeah,
has to be delivered. And, delivery of resale package must be made directly to buyer, delivery to buyer's agent is, so again, it was
it, it
delivered.
if you can prove that it was delivered, it's delivered.
Exactly.
Perfect. Thank
No problem. Okay, you guys. So going on to the next thing, again, Eric asked me, hey, Sarah, what do you prefer, MAR or GCAAR? Well, guess what? GCAAR decided to put this addendum where now we are changing things, and that includes the definitions. They are changing the definitions in the MAR contract to align with the definitions in the GCAAR contract. This is the biggest thing. Again, I do business in all three jurisdictions, right? I do business in Virginia, Maryland, DC. I do a lot of MAR. I will tell you that the biggest thing that I see is MAR agents, because the MAR contract says that the day goes through 11/59/59. forget that GCAAR and NVAR have a different timeline. So this addendum modifies the MAR contract to state that now for purposes of computing time periods, the first day will be the day following delivery, and the time period will end at 6 p.m. on the day specified. This is for everything except HOA, condo, or co-op docs, which go through 11/59/59. But be very aware, because this does change the timeline as to the end of the day for a MARC contract when you're doing business in Montgomery County. It changes the timeline to 6 p.m. to accommodate the GCAR stuff. And I think this is the biggest mindset shift for a lot of my MAR agents, because, a lot of times they're like, well, Sarah, my clients, are a school teacher or work at a base or whatever, and don't even get, their phone until 5, 6 p.m. This is ridiculous. Well, then change it. But that has to be changed by both parties and agreed to both parties. But just please notice that this is in this addendum, and it does supersede whatever the MARC contract says. So that is a big, 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 big thing. Okay, you guys. Next is the Form 1381. This is the tenancy addendum for District of Columbia 2 to 4 units accommodation. Oh my God. As you all know, TOPA changed May 2026. And what happened was that DC changed the law, which, hey, great law. I think it's great. We have a TOPA class. But in that, they said, hey, you now, seller, are required to send a notice. And they didn't define the notice. And they didn't put out there what the notice had to say. And they didn't do any of those things. So GCAAR couldn't change this form until DC came back and decided the specifics around it, as well as, and actually, May 2026 was when the form came out. The law was retroactive as of December 2025. So that's, December 2025, they passed it January, I think it was like 17th, and they said, we're going to make it to go back to December 2025, but they didn't put out forms, they didn't put out guidance. Guidance did start coming out. Now we do have a form that's blessed by DC. How many of you guys actually do deal with anything under TOPA for DC? Okay. Well, if you do have any TOPA questions, it's a little complicated, feel free to call us. We'll help you through TOPA. What you need to know with this form is that, now paragraph 3 was updated to talk about what the new requirements are. And with the new law, it says, is the seller exempt from these TOPA provisions? Or is it not? And then it tells you the required notice if they are exempt and the required notice if they are not exempt. So I think they did a really great job, because what they did is you don't have to go looking at the DC website. You can just look at the form and it'll tell you exactly what forms need to happen. Where do you find those forms and what you need to do in order to be in compliance with that. So moving on is, okay, I was also part of this form. So if you hate it, you can let me know. And did you know that the state of Maryland requires real estate agents to verify licenses of home improvement contractors and their status before referring them? Well, if you didn't know, this is your PSA that Maryland law obligates you to verify that these people are licensed before you refer them.
Can you repeat that? Can you repeat that, Sarah?
Yeah.
Repeat it really loudly, please.
This is your PSA that if you are going to refer a contractor to anyone as a real estate agent, whether they are your client or not, the law requires you to verify their licensee status.
Yep.
So what we did is we created a notice of home improvement contractor licensing status, where you can put the name of the home improvement contractor. We give you the link in which you can go ahead and look them up. You could put the license number if applicable or available. the date the license status was verified and the date that the license expires. Now, the law only requires that you verify it and you put the date in which you verified it. But we put date license expires to safeguard our realtors, because what if, you know, you verified it August 2026 and then in November it's expired, you gave this to somebody and it's expired and then they try to sue you. And then the other thing that I will tell you with this is that, you know, again, we put consumer and not client, because the law obligates any real estate agent to verify this, even if you're talking to a neighbor, if you're talking to someone at your child's school, if you're talking to any single person, the law requires you to do that because you're a realtor. So in order to safeguard you, we created this form. It's pretty easy, and it is form 1370. Oh,
Why didn't they not just put the onus on the recipient of the information to verify it? Why is it all heavy on the agent?
because it's Maryland. Where do you live, Eric?
I live in Virginia. I got property over in Maryland, though, but Jesus
It's
Christ.
yep, that you can thank the legislature for that.
So I will tell you, so I live in Virginia, but I own, you know, companies in Maryland, Virginia, DC. And I can tell you that as a whole, the law in Maryland is very protective of others. Whereas Virginia is kind of like buyer beware. It's on you. You know, it's on you. Maryland is
You know, if
not.
I have this, there's no chance I'm giving anybody a contractor.
Yeah,
Well, pretty much. But that is the law. Unfortunately, it's the
that's
law.
and that is an advisable strategy.
Mhm.
You want to be as helpful as you can to your clients. That's a
I mean, if I look
that's
this
a
up and
natural
I make a
tendency of
mistake,
agents.
I make a mistake on this form
Yeah.
and I have their license number off by one digit or the expiration date off, all of a sudden, you know, it's my problem.
Yep.
That.
But that's the nature of
So
Maryland.
wait, Eric. It doesn't say if it's a number off, it doesn't make you liable. The only thing the law requires is for you to verify their license status once a year.
But if I verified it and I filled this form out and I put date license expires and it was 2026 and I put 2027, yeah, no
Mhm.
thanks.
Yeah.
Are they trying to make it an attorney state like New York?
I don't think so. I will tell you though that again, Maryland just seems to become more and more putting the onus on everybody except who they call the consumer. So, you know, again, just be aware, because this is a state law requirement. It is not a GCAAR requirement. It's not we wanted, you know, this is for your information. If in the state of Maryland, you recommend a home improvement contractor, then you have to
Well, I'm an
verify.
agent. I recommend Joe Schmo to my tenant. I have to fill this form out.
Yeah.
Same and DC has enacted the same provision as well.
I ain't getting into DC. Forget that.
DC has done the same thing about with this thing, so it's obligated in DC and Maryland.
Yeah. Yeah. So yeah, Eric, you're absolutely right. I mean, it's one of those things where it's like you would think that people, you know, and we even put it in there. It says, I understand that before entering into any agreements or service contract with a contractor, it's important to confirm that the contractor holds a current license, but the onus is on you to verify that they are licensed. So just be aware of that. Okay, we're getting to the end. Hang with me. Just, you know, we have 15 minutes left. We only have, I think, 2 more forms. Or maybe this is the last form. This is form 910, and then you have the other one that I didn't put in here, but it is a 909. It is just the listing agreements being updated in order to talk about the amount offered. So as you know, and so Eric, I know you must do a lot of Virginia. Kathy, do you do a lot of Virginia, Maryland, or DC?
Mostly Maryland now. When I first started out, it was heavy Virginia, but it's really flip-flopped to mostly Maryland now.
Okay. So this one was one of the biggest changes how all the associations handled it. When the NAR lawsuit came and everybody had this thing about what you could do or you couldn't do, I think honestly, NVAR handled it the best. Because in the front page of the contract, it says, seller paid buyer broker's commission. You negotiated in the contract. You don't have to disclose it. It's a negotiated term. Boom, bam, thank you, ma'am. Maryland has a very different way of doing it. In Maryland, especially on most of the time, the MAR agents, so not necessarily those in Montgomery County, but the people that are in MAR, they want to be able to authorize to be able to say or market the amount that they're willing to pay. My opinion as an attorney is that this is very dangerous, even if the seller is allowing you to market it. But the committee decided that they wanted to put a part into it where it stated if seller authorizes listing broker to disclose seller's willingness to pay buyer broker compensation in paragraph D2, the seller hereby authorizes listing broker to market seller paid buyer broker compensation in the amount of X.
And you're saying that it's dangerous because it butts right up to the settlement agreements, right?
Yeah.
And the terms of the settlement agreements specifically were very they were getting right close to the line of what we're talking of the distinction between those two things.
So I'm going to tell you why, and I'll tell you this. Again, I know Eric and Kathy and Ali don't know me, but um, you know, I'm part of NAREP, which is the National Association of Hispanic Real Estate Professionals, which is a nationwide organization with 80,000 members. And we sat down at the table when all of this was going on with NAR, their attorneys, etc. And we can tell you that the crux of the matter was that the sellers were suing these listing agents saying, we didn't know we could negotiate. We didn't know we could negotiate, that this was negotiable. Why I think this is dangerous is because I foresee people being like, hey, you really want to offer X, Y, or Z to have people come. So it's in your best interest for me to put this amount so that you can get more people. And depending on how you say it, you could open yourself up for a lawsuit saying that you didn't make them understand that it was negotiable. I like the fact that, hey, it's negotiable. You want to offer me full listing price? Well, the seller will pay you a commission. You want to offer me $50,000 less? We're not going to pay you, my net wants to be X, Y, or Z. Make it about the dollars instead of what we are offering. So
Ali, are you understanding what we're talking about here as a new licensee?
I'm catching on.
Okay. Just want to make sure that you're following it.
Ali can text me anytime, email me, any of you guys. If you have any questions or concerns, I'm happy to.
So Sarah, would you, based on what you're saying, right? Dan's not going to agree with this one for sure, but I do not agree with this paragraph. Can I chop it up a little bit and say up to or TBD or we'll figure it out later?
So what I would do if I were you, Eric, and I agree with you. I hated this paragraph. I fought for it, but I think it will get agents sued because the problem is that I was talking to somebody else and they said, they were trying to fight. They were trying to fight someone for the EMD. And they were like, but it's the principal. And I'm like, is the principal going to pay the attorney's fees? So I think this is one of those situations. You don't have to use it, Eric. You go to D2, seller authorizes listing broker to disclose seller willingness to pay buyer broker compensation, and you leave it like that.
Exactly.
You don't have to use 3. I encourage you not to use 3. 3 is
Just because
only
it,
saying,
yeah, just because it's there doesn't mean you have to use it.
yes.
And you're not changing it. You're just ignoring it.
Yeah, I would recommend not touching it. Don't
Yeah.
tweak it, don't change it because you can change it and then you might get into trouble violating the law. Because did you guys notice that what we heard from NAR was their version of how they settled, but nobody's actually been able to see that agreement. So we don't know. So I don't want, so again, if let's say, Kathy says she does a lot of MAR or a lot of Maryland. And let's say that Kathy says, well, Sarah, that's something that I have to do in order to be able to get people to my listings. If you want to use it, use it. Then say, hey, but it says seller authorizes listing brokers to disclose this specific amount. Then you do that. But if the seller doesn't authorize it, then I wouldn't fill it out. You don't need to use it.
Yeah, I mean, I don't like, that paragraph at all in the vein of because, in my opinion, the seller needs to see the offer in its entirety. And so this forces a hand prior to even knowing what the other terms are. So I do always put does not authorize in the vein of I talk my client through it and say, you know, am I allowed to say to them, here's this side, here's, if we do it this way, this is the traditional way it's going to settle out. If we do it that way, here's what that's going to do. It's your choice how you want me to handle it. But in most cases, the seller wants to, because they'll always say to me, well, it depends if they ask for closing costs, and it depends if they're going to settle in, 30 days as opposed to 60 days, and I have carrying costs for another additional month. I want to know the entire thing. And so, when I get a call about it, which I think everybody's been very tentative when I have a listing to call me and ask me if the seller is willing to compensate the buyer for the buyer agency compensation. Everybody's kind of gotten really scared to even have that discussion from my point of view, the people I'm dealing with. And so I just tell them, that the seller is going to look at the entire offer and make a decision on what they feel is in their best interest to accept. And so it's just kind of, to me, they keep muddying this more than what they need to.
And I agree with you, and that's best practices. But I want to note, so 2 and 3 are very different. I would put D2, seller authorizes listing broker to disclose seller willingness to pay buyer broker compensation. Because what that means is, Kathy, you call me and say, hey, is your seller open to pay my buyer broker commission? What that allows me to say is, it depends on your offer. If your offer is good enough, yes, my seller is willing to pay a buyer broker compensation depending on your offer. Point blank. I don't have to say a number. I don't have to say anything. If you say does not, you would have to answer, I can't discuss that. I am
Yeah,
not
and
authorized to discuss that.
number D2 also, I mean, it specifically says a willingness to pay the buyer so to pay buyer broker compensation. It doesn't say a number. It doesn't say anything like it doesn't define what that number is. So it implies by the way the wording is, it implies that it has to be specified into the contract. And if it's not specified into the contract, then we're not offering anything.
Yeah.
Well, Sarah, what
And
do you
then
think is the
what,
biggest, Sarah, what
go
do you
ahead.
think is the biggest misunderstanding of why this matter? I mean, to me, it seems so simple. I mean, net is net. I don't care if you buyer agent asks for 10%. If the offer, if you give, it gives a cash offer and it's, 200 grand over list or whatever the numbers, net is net. I don't care what the commission is. Why does everyone get so wrapped up in it? And what I found is that it's the agent on the other side. Personally, what I found is the agent on the other side is either a pansy or is making less than my comp, and then they have a problem with it.
So what I think, Eric, from what I've been able to see is that a lot of realtors don't want to have a conversation with their clients as to how payment goes. And they don't want to tell somebody, hey, I'm going to help you and I'm going to do X, Y, or Z, but this is my compensation. So then they want to see how much the other party is paying so they don't have to go to their buyers to ask them for the compensation. This is an old way. Again, like I said, I think the tide will turn eventually. What is different from 2 to 3 is that 3 is the seller authorizing you to market an amount. So what number 3 says is the seller is authorizing me to market, hey, come sell my house and I'm giving you 3 chickens or 3 cows or, 4 donkeys. Whereas number 2 says, my seller will take any offers, and depending on your offer, we might or might not pay you compensation. Give me your best offer. Right?
So I think some of these, how do I say, perhaps less experienced agents are telling their seller, I'm doing a net sheet for the seller, they're doing a net sheet for the seller, they're telling the seller they don't have to pay any buyer agency comp, which is in effect true, but in reality, rarely happens. So their seller now thinks, oh, well, I don't have to pay any comp. That's not on my net sheet. So then the problems arise come contract time.
Well, I think it's worse than that, Eric, if you want my humble opinion. I think a lot of realtors are, so again, the lawsuit was because seller said, hey, you never told me that this was negotiable. To Kathy's point, what if they're offering me $50,000 less with with me paying a rent back, with me doing all these things, and I think realtors are telling their sellers, you need to offer 15 donkeys for me to sell the property or no, we're not going to sell it. And I think this is listing agents not understanding that the market has changed and feeling like they need to offer a specific amount to be able to sell the property versus saying, hey, everything in life is negotiable. Make me your best offer and we'll take it from there. And this is why I don't like it, because I feel like the conversations around number 3 are going to be difficult. And I feel like the conversations are around number 3. Most people are not going to have the conversation, or even if you do, if a seller comes back and sues you and says, well, they told me that in order to get more people, I had to offer, this. How are you going to show that you, in fact, did have a conversation with your seller and told them that it was negotiable and that it depending on how much other people had? So that's why I don't like that green part. Number 2, I would say seller authorizes listing broker to disclose seller's willingness to pay buyer broker compensation, because the only thing that means is you're saying, yep, we're willing depending on your offer. It doesn't say amount.
Isn't everyone
Not hearing you, Eric.
Yeah.
Not hearing you.
Isn't everybody willing to pay it?
Depending on the thing, yeah, but I mean, I'm not sure if people are willing or not willing, so I can't.
It
I
just seems like it's a horse that keeps getting beaten, and that's
agreed. Well, listen, you guys, we're right on time. I wanted to thank you for your time. I've put my email address there, as well on your chat. You have my cell phone number. Text is the best way to get a hold of me, just because, as you can see, even if I am, on a class or something, I can get to my phone afterwards. If you have any questions or concerns, feel free to, reach out. Dan?
Yeah, and folks, just give Sarah and Titan Title an opportunity to serve you in your next transactions. She's very powerful, very knowledgeable across the board, and she's got offices in Fairfax, right? She's got an office in Fairfax, Vienna. Is it in Vienna?
Well,
No.
I have multiple office spaces I can use all across Virginia, Maryland, DC, and Florida.
Okay. Yeah. So she's got a Bethesda office and there's Fairfax and all kinds of other places, and Kathy, she serves Prince George's County too. So
Okay.
Thank you,
so
Dan.
happy. Yep. Please give her a chance, and thank you all for joining us. Much appreciated.
Thank
Thanks,
you.
Sarah.
Thank you,
Thanks,
everyone.
Sarah.
Thank
Have a
you,
great
Thanks.
rest of
guys.
your day, guys.
Thank you,
Have a
Sarah.
good
Thank you,
one.
Dan. Thank you, everyone.
Bye.
Yep.
Thank you.
Bye-bye.
Bye-bye.
Take
Thanks,
care.
Dan.
Okay,
Bye.
bye.